Just a few minutes ago, my office filed a lawsuit against the National Rifle Association to dissolve the organization in its entirety for years of self-dealing and illegal conduct that violate New York's charities law and undermine its own mission. The National Rifle Association, or the NRA, is the largest and most influential pro-gun organization in the nation. Since its founding in 1871, the NRA has been a registered not-for-profit charitable corporation in the state of New York. The Attorney General's office has a wide range of regulatory and enforcement powers over charitable corporations and their trustees, including the NRA. The NRA's influence has been so powerful that the organization went unchecked for decades, while top executives funneled millions into their own pockets. For years, the NRA diverted millions and millions of dollars away from its charitable mission for personal use by senior leadership, to award contracts to the financial gain of close associates and family, and appeared to dole out lucrative no-show contracts to former employees in order to buy their silence and continued loyalty. This lawsuit specifically charges the NRA as a whole, in addition to 4 individual defendants. 1, the first individual, longtime Executive Vice President Wayne Lapierre, who has been the face of the NRA for decades. 2, former Treasurer and Chief Financial Officer Wilson Woody Phillips. 3, former Chief of Staff and the Executive Director of Operations Joshua Powell. And 4, Corporate Secretary and General Counsel John Fraser. These individuals in the NRA are charged with failing to manage the NRA's funds and failing to follow numerous state and federal laws, which contributed to the loss of more than $64 million in just 3 years. Since its founding in 1871, the NRA has been a registered not-for-profit charitable corporation in the state of New York. And these organizations are required by law to register and file annual financial reports with the Office of the New York State Attorney General, and the assets of such an organization are legally required to be used in a way that serves the interest of NRA membership and that advance the organization's charitable mission. However, as today's complaints lays out, we found that the NRA instead fostered a culture of non-compliance and disregard for internal controls that led to the waste and loss of millions in assets and contributed to the NRA's current deteriorated financial state. Not only were the NRA's internal policies repeatedly not followed, but they were blatantly ignored by senior leaders. The NRA's board's audit committee was negligent in its duty to ensure appropriate, competent, and judicious stewardship of assets by NRA leadership. Specifically, the audit committee failed to assure standard fiscal controls. They failed to respond adequately to whistleblowers, affirmatively took steps to conceal the nature and scope of whistleblower concerns from external auditors, and they failed to review potential conflicts of interest for employees. In our lawsuit, we outlined dozens of examples of these failures, many of which were led and perpetuated by the 4 individual defendants named in this lawsuit, who failed to fulfill their fiduciary duty to the NRA. They used millions upon millions of dollars from the NRA for personal use, including for lavish trips for themselves and their families, private jets, expensive meals, and other private travel. Wayne Lapierre, Woody Phillips, Joshua Powell, and John Fraser instituted a culture of self-dealing, mismanagement, and negligent oversight at the NRA that was illegal, oppressive, and fraudulent. They overrode and they evaded internal controls to allow themselves, their families, and favored board members, employees, and vendors to benefit through reimbursed expenses, related party transactions, excess compensation, side deals, and waste of charitable assets without regard to the NRA's best interest. The central figure behind this scheme was none other than Mr. Wayne Lapierre, the national face of the NRA, who was entrusted with running its day-to-day operations. Mr. Lapierre exploited the organization for his and his family's financial benefit and the benefit of a close circle of NRA staff, board members, and vendors. Specifically, Mr. Lapierre spent hundreds of thousands of dollars of the NRA's charitable assets for personal private plane trips for himself and his family, including extended family when he was not present. He visited the Bahamas by private air charter at least 8 times in an approximate 3-year period with his family at a cost of more than $500,000 to the NRA. He traveled on multiple luxury hunting safaris in Africa at the expense of an NRA vendor. He spent millions of dollars on unwanted travel consultants for decades, including for the booking of luxury black car service. In the past 2 years alone, Mr. Lapierre spent more than $3.6 million on these travel agent services. He secured a post-employment contract for himself with the NRA without board approval, currently valued at more than $17 million. He allotted several million dollars annually in NRA funds for private security costs for himself and his family without sufficient oversight on their use. He received more than $1.2 million in reimbursement in just a 4-year period for expenditures that included gifts for favored friends and vendors, travel expenses for himself and his family, and membership fees at golf clubs, hotels, and other member clubs. He even secured lucrative consulting contracts for ex-employees and board members worth millions of dollars. Yet often it resulted in little, if any, actual work. In addition to grossly misusing these funds for personal use, Mr. Lapierre created an illegal pass-through arrangement to conceal the very nature of these expenditures. For decades, Mr. Lapierre and the founder of Ackerman McQueen, the NRA's longtime advertising firm, had a practice whereby Ackerman McQueen would pay for these non-contractual, out-of-pocket expenses for Mr. Lapierre and other NRA executives and pass those expenses through to the NRA. These expenses would then be paid for by the NRA without written approval, without receipts, without any supporting business purpose documentation. Ackerman McQueen would aggregate the expenses into a lump sum amount and then bill them to the NRA without any details on the nature or purpose of the expense, completely in violation of state law. These expenses did not comply with IRS requirements, and as a result, all such expenses should have been included by the NRA in taxable personal income for Mr. Lapierre and other recipients. In 2017 and 2018 alone, just 2 years, Ackerman McQueen was paid more than $70 million. A significant amount of these funds included payments through this side agreement. And when board members challenged Mr. Lapierre and the 3 other defendants over this lavish spending, their financial governance, or their leadership of the NRA, Mr. Lapierre retaliated and turned the board against those who attempted to challenge his illegal behavior. The complaint lays out numerous other instances in which Mr. Lapierre, Mr. Phillips, Mr. Powell, and Mr. Frazier, and other executives and board members at the NRA abused their power and illegally diverted or facilitated the diversion of tens of millions of dollars from the NRA. These funds were in addition to millions of dollars the 4 individual defendants were already receiving in grossly excessive salaries and bonuses that were baseless and did not adhere to prudent standards for evaluating and determining compensation as is required by law. Altogether, there are 18 causes of action, and these actions violated multiple laws, including the laws governing the NRA's charitable status, false reporting on annual filings with my office and the IRS, improper expense documentation, improper wage reporting, improper income tax withholding, failure to make required excise tax reporting and payments, payments in excess of reasonable compensation to disqualified persons, and waste of NRA assets, amongst other offenses. For these years of fraud and misconduct, we are seeking an order to dissolve the NRA in its entirety, to require Mr. Lapierre, Mr. Phillips, Mr. Powell, and Mr. Frazier to make full restitution for funds they unlawfully profited in salaries they earned while employees and pay penalties, to remove Mr. Lapierre and Mr. Frazier from the NRA's leadership, and to ensure none of the four individual defendants can ever again serve on the board of a charity in New York State. It's important to note that Mr. Phillips and Mr. Powell have left the NRA. It's clear that the NRA has been failing to carry out its stated mission for many, many years, and instead has operated as a breeding ground for greed, abuse, and brazen illegality. In this state, we have a set of laws that every individual and entity must be held accountable to, regardless of who you are, regardless of your power, size, influence, wealth, or station in life. One set of laws. And today, we send a strong and loud message that no one is above the law, not even the NRA, one of the most powerful organizations in this country.
Hi everyone, George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel, and don't forget to download the ABC News app for breaking news alerts. Thanks for watching.